Yes.
My Lord, thank you. I was taking the court through the decision letter. It's within the core bundle. With reference to page 119 of the core bundle, I was discussing the implications of the menu. I will very briefly conclude that.
So sorry. I think I took that time. Back. I'm sorry. Oh, I find it. Sorry. By my lunch.
At paragraph 24 of that decision, the review officer says, on the odd day, there might be an option that's not considered healthy. In my submission, that misses the point. It's neither here nor there whether it's healthy. This is a question of the appellant's disability. She has type 2 diabetes, and there will be days when she cannot eat from the menu which she is paying for via a service charge. The properly reasoned decision in response would have said, what are the cost implications of that odd day where you cannot eat any of the options available?
Sorry, where does you cannot eat? They're both carbohydrates and fish and chips are both, sorry, pizza and are both, and fish and chips are both carbohydrate heavy.
They are, yes, ma'am.
That doesn't mean that a diabetic can't eat them.
No, but the reviewing officer is here conceding that there may be days when the food is not appropriate, and the reviewing officer is phrasing it in terms of being healthy, but that's not engaging with the point. The point being, there will be days, in fact, that there is in my submission, and we've looked at the menu to some extent, the whole menu is carbohydrate and sugar heavy. So if there are days when she can't eat it at all, and that's the material question, are there days she can't eat it at all?
But you're missing the point. She can eat it. Nobody says a diabetic can't eat pizza.
Yes.
The medical evidence isn't to that effect.
No.
Common experience isn't to that. You just don't want to eat pizza every day if you're a diabetic.
Yes, my Lord. Well, we have no evidence about the consequences of that. We do know from page 326 that the health advisor said reduce her sugar and carb intake. And that's summarised by the review officer at paragraph 26. The review officer says, on the 15th of March, that's summarising this advice at page 326. I spoke to the health care advisor assistant who is involved with you, and she confirmed that you've not been advised to avoid any specific food. But that omits the most material point, which is that you have been told to reduce your sugar and carb intake. And it's that key piece of information that is the consequence of the disability. Now, the question the review officer needed to ask herself was, if that is the consequence of the disability, are there days when the menu is such that, is the menu overall going to render the service charge discriminatory in effect? Are there days when you're going to be unable to eat this food? And I say unable, taking my Lord's point into advisement there. It's unable in inverted commas. However, if there are days, or if there are whole weeks, when the appellant is going to have to spend the residual income that she has, which is only £38 per week, feeding herself as an alternative to the menu provided for the service charge that she pays, then there is a discriminatory effect of the service charge.
I mean, she, I don't want to be rude about this, but her BMI is exceptionally high.
Yes, my Lord.
So she needs to lose a massive amount of weight, I have no idea how much, in order to be healthy.
Well, we have no evidence about that, but as a matter of common sense,
well, no, it's just 42 is extremely high. It's morbid obesity.
Yes, my Lord.
And I'm just slightly concerned about injecting just a tiny bit of reality here.
Well, my Lord, the implication of my Lord's point, I suppose, is
eat less.
Eat less, which is on the face of it would be generally good advice. But how a person with a BMI of that magnitude.
I'm just looking at the thing. I mean, I don't know what I don't know what the parameters are, and I never understand quite how it's calculated. But a person weighing 250 pounds at 5'6" has a lower BMI than she. So
Yes.
so she must be quite overweight.
But the advice about how to lose weight is probably complicated.
Well,
and
it's
not
complicated in one sense and not complicated in another. It must be lose weight. I mean, to say that she needs to go out for expensive meals instead of just having the vegetables from the side dishes on a day when it's carbohydrate is strange to me for somebody of that level of obesity. I mean, you know, I'm afraid we have to inject some realism.
Well, in my submission, my lord, this would have been exactly the sort of thing that a now medical report would have been able to comment on. If they could say the healthy way for a type 2 diabetic to lose weight, which is a priority with a person of that BMI, would have been to say only eat the vegetables, then...
This is what this report says. It says you can choose your side dishes.
Yes, but that's not medical evidence about how safely a type 2 diabetic can lose weight. That would be a matter in my submission for expert evidence.
Okay. Can I just develop that point a moment? Broadly, it's in the discretion of the local authority or the review officer what inquiries they carry out. If they unreasonably fail to carry out some inquiry, then you can complain about it. But broadly, it's up to them to decide. In circumstances where the medical conditions are relatively common ones on which you can see NHS advice, where your solicitors say, look, speak to the GP, and the review officer does that and speaks to the medical health assistant. Can you say it was unreasonable not to take some further medical advice?
I would make that submission. I would make it by reference, however, to Peretti, which interprets the duty to make inquiries, and that is within the authorities bundle. I can take my lord to it if it would assist, but essentially...
Which paragraphs in that case?
Sorry, my lord just...
Did you say it's called Peretti?
Peretti, yes, my lord, yes.
So.
Essentially, Peretti is authority for the proposition, and I will find the paragraph reference for my lord momentarily, for the proposition that if some feature of the evidence raises a realistic possibility of disability, then that
But
hits
there's no
it.
doubt you've disabled, is there?
Pardon?
Is there any issue that you've disabled?
Well, it's conceded at paragraph 40 of the decision letter, but it's not said how she's disabled or in what way and with what
Oh, I see,
consequence.
Okay, but sorry, it's the proposition you put in from Peretti was simply about whether there was a disability, but that wasn't an issue.
Whether there is a disability, if some feature of the evidence points to the fact that there's a disability, then further inquiries are necessitated.
But that is a different question, isn't it? Because
It is.
the review officer has proceeded on the basis that there is a disability. He's proceeded on the basis that he knows what the medical conditions are. The only further question is what has to be done about that? And there he had a variety of sources of information. Why wasn't it reasonable for him to decide he didn't need to do any more?
Well, because what my lord, the point my lord was just making was that this is, well, what my answer to my lord's point was that this is about an interaction between two different disabilities. For instance, if there's a very high BMI, a person plainly needs to lose weight, and I accept that as a matter of common sense. But how they do that safely if they're a type 2 diabetic is, in my submission, a question that is properly put before somebody who is medically trained, and that's the purpose of that now medical report which local authorities routinely obtain in these sorts of cases.
But what the review officer himself has said, he hasn't actually said you better not eat anything because that'll make you slimmer.
gone through and concluded in 25 that he's satisfied that the hostel does meet the dietary needs, having addressed the question of fish and chips and pizza, and then he, having had your response to the minded to document, he's gone to the GP, he's gone to the medical health assistant, and then after also considering the NHS guidelines, he says, I'm satisfied that your accommodation is suitable in terms of the cooking facilities and your medical conditions. So he's not saying, oh, look, you better just lose weight. He's come up with a much more sophisticated answer than that.
He has come up with a more sophisticated answer, but not one that's based on medical evidence, and not one which, in my submission, fairly summarises what was found when the GP was inquired of. So at 26, that summary of what was said to the review officer on the 15th of March doesn't reflect the notes about what was said by the advisor on the 15th of March at page 326. It's just not the same information. The review officer summarises it as, you haven't been told not to eat any food, but omits the material point, which is that you have been told to reduce your sugar and carb intake. So yes, the review officer does come up with an answer, but not one that engages properly with the definition, the way in which she is disabled, and the consequences of the disability. And I make that argument by reference to Peretti first at 35, that's paragraph 35. Lord Justice Wilson held, if the evidence indicates there may be a disability in issue, it was for the local authority to make inquiries. So I say those inquiries were not sufficient, and then the extent to which they were made, they were unfairly summarised at 26. It doesn't accurately reflect the meaning of what was said by the health advisor. But relatedly, what needed to happen then, so if some feature of the evidence suggests per Peretti at 35 that there may be a disability and the duty to make inquiries on that specific point arises, then what must inevitably happen next is that the structured approach is taken, and we get this from Hackney and Hack. Hackney and Hack is at page 202 of the authorities bundle, and essentially Lord Justice Briggs describes the facts at paragraph 7 to 10. This is a man suffering with a physical disability, and the reviewer needed to take a structured approach, but what did that mean? So at 21, the point is made that the public sector equality duty, which arises under section 149 of the Equality Act, the point was to bring disability into the mainstream. At 22, the court notes that successfully discharging the duty required substance over form, and at 27, there would be almost complete overlap between consideration of priority need and what it meant to have a protected characteristic for the purposes of the public sector equality duty. At 41, the court notes that a review officer might satisfy the requirements necessary to discharge the PSCD without even expressly acknowledging that, because it is substance rather than form. But at 43, the court notes this must be done in any event with rigour and an open mind. 43 to 44. In my submission, had this sharp focus with rigour and an open mind, and the steps described at 43 to 44 been taken, the lawful approach by the review officer, then the question became, what are the additional cost implications of a menu that is carb heavy where you have been advised to cut down your carbohydrates? And secondarily, if there are cost implications of it, can that be considered to be a discriminatory effect of the service charge?
Before you go there, which of the steps in 43 were not taken?
So there must be recognition of the impairment. The aspects of that impairment must be identified, the consequences of the impairment and the needs arising from it, and the recognition of the need to potentially treat an applicant more favourably are the requirements.
And are they not all apparent from the review decision?
Well, In my submission, no. If we look at paragraph 40 of the review decision, which is on page 122 of the full bundle, first sentence of paragraph 40, I have had regard to the Equalities Act where I do consider you to be disabled, but it is not said in what way.
Well, it's clear in what way, isn't it? It's
Well,
had regard to the consequences of the diabetes.
Well, actually, in discussion now, we have said that it's diabetes, yes, but it interacts with other ailments. For instance, the elevated BMI and
The BMI. So sorry about the blood pressure. No, forget me. Elevated BMI. Yeah.
those two impairments do interact in a way that's potentially highly significant, but that's not identified. The impairments that aren't identified, the consequences flowing from the impairments aren't identified, and the needs arising from those impairments aren't identified.
Well, isn't that what it's doing earlier? Say in the section we were just looking at, dealing with food. Is he not working through the implications?
Well, one of the implications is to reduce sugar and carb intake. We've got that from page 326. That's what the GP health advisor said. That doesn't make it into paragraph 26 of the decision. So no. Plainly, the translation between the information provided by the GP, which is describing the consequences of the disability, do not make it so far as the review decision. And 26 is a very good example of that. The summary is you haven't been told to avoid any specific food. That's only half, and in my submission, the less significant half of what the health advisor said. And so it is a failure to identify the consequences of a protected characteristic.
Okay, well, I wonder whether we've got that point on diet. What are the other criticisms of the review decision?
Thank you. Yes, in conclusion of that point, my closing remark on that is only to say this. If there is a discriminatory effect of the service charge, then that is something which the review officer needed to take into account when they were saying you must subsist on £38 per week. If there is an odd day when you can't eat, it will reduce that £38 per week, and I either find that to be acceptable or not. But to not engage with that question is the error of law, and that's the problem with the decision letter when it comes to food and cost. And those are essentially my points as to ground 1 and ground 2 in the statutory appeal. The only other point to make on cost is what's missing from this review decision is any subjective input from the appellant as to the cost, particularly the cost implications of her managing her health despite having to pay the service charge. So when cost is considered, and it is considered by the reviewer in terms of the suitability of the accommodation, generic information is used from housing advice services. Now, it's unproblematic in and of itself to use objective information, but the point of the objective information is that it is used to weigh against the subjective input of the applicant, and there isn't any subjective
What's
input.
the authority for that?
Well,
why can't you just rely on objective information?
Well, in Samuels, there is objective information, and so although Samuels isn't authority for that proposition, it is in Samuels assumed in my submission that there's going to be some subjective input from the applicant. It would appear to be relatively unusual because there is usually commonly a form is used by a respondent local authority to say what are your expenses, and that's completed by an applicant saying what they spend on various household needs. Again, that's not information that was obtained from the applicant. It isn't in the, for instance, personal housing plan, and it doesn't make it into the decision. And
We were given the minded to document
We were
in
given-
response to an opportunity to respond to that, and I think you made it point about bus fares,
Bus fares, yes, because they hadn't been included in the.
but you didn't make other detailed points, did you?
No, I think it's correct that we highlighted travel as being the main omission. At paragraphs 34 and 35, the review decision engages, the review officer engages with the question of sharing facilities. There are two erroneous statements in these two paragraphs. The first is in the middle of paragraph 34. There's no evidence you need to use the toilet every 20 minutes. That's correct, because the evidence predates her placement in the hostel, and the point that's being made by her solicitor in her submissions is it is the effect of the food causing the blood sugar levels to fluctuate, which leads to the lavatory being required every 20 minutes. So yes, but the evidence wouldn't show that, because the evidence is from a time when she didn't reside at the hostel. So again, this is not engaging with an open mind and the rigorous approach required with the consequences of disability in terms of sharing facilities. And similarly at 35, there's a toilet adjacent to your room. Yes, that's true, but it's a toilet which is shared by all of the other people in the hostel. So there are either 6 or 8. I don't think we've come to the bottom of that factual dispute, but there are at least 6 rooms all sharing one toilet. If the applicant needs to use it every 20 minutes, it inevitably involves her having to wait to do that and a loss of, she said, dignity with her position. So again, saying the toilet's adjacent to your room misses the point and fails to engage with rigour and an open mind with the consequences of the disability and the suitability of this accommodation for a person with these protected characteristics. So in my submission, an error of law relative to Hackney and Hat. Finally then, at 37, the review officer makes a concession. The accommodation is not ideal for you. The reviewing officer says that they are not satisfied that the accommodation is unsuitable for you. But they do concede this is not ideal. That makes it particularly important in my submission for the reviewing officer to make clear what relative assessment of suitability they're employing here. So we have from Al-Kundi and we have from Ali the proposition that suitability is always going to be relative to the period of time for which a person is occupying accommodation. If it's not ideal, I appreciate that that's no legal test. If it's not ideal, but it's still suitable, what is it suitable for? And we know from Al-Kundi at 83, paragraph 83, the letter is supposed to make clear what questions are being asked and what conclusions are being reached. In my submission, paragraph 37 is not doing that. It muddies the water somewhat by saying it's not ideal, but most problematically, there's no statement of what suitability is being considered relative to here. Is it just relief duty accommodation suitability, or is it suitability in terms of discharging section 193? And that brings me to one final point which I just wanted to make in relation to a question that my lord raised earlier, which is what's suitable in the short term and the medium term and the long term we know is different. So we know that from Ali. We know from Al-Kundi that the distinction must be made clear in the decision letter as to which type of suitability we're considering. But my lord said earlier, if you make within the relief duty phase, provision of accommodation which would be suitable for the long term, so for discharge of section 193. Isn't it the case that you would not get to section 193? And I concede that yes, that is potentially the implication, but the questions would need to be asked, and moreover, in that scenario highlighted by my lord, if you were to make that decision, you would have to provide a properly reasoned, in inverted commas, not homeless decision. The reason you would have to do that is because section 1843 provides that decisions adverse must be properly reasoned. The reason I make that point here...
Could you just tell me why paragraph 39, under the heading not homeless decision,
Yes, ma'am.
says, I'm satisfied you have accommodation that is available for you longer than 56 days and which is also reasonable for you to continue to occupy. This is based on the details I've provided above. This means that you're not homeless and that the main duty does not apply. So he is there considering the question of reasonableness of continuing occupation and suitability under the three headings.
Well, no, my lord, in my submission that's not what's happening. If we look at what's required by section 1843, at authorities, page 14, on completing their inquiries, the authority shall notify the applicant of their decision, and so far as any issue is decided against his interest, inform him of the reasons for their decision. Now, my lord's anticipated me because I was going to say, merely stating in one sentence, this is based on the details I have provided above, particularly in circumstances when the details provided above have failed to adopt the structured approach or based on inadequate, we say, inquiries and based on a plan which is silent as to housing needs, it cannot possibly be the case that those reasons contained in this decision are sufficient for a section 1843.
Why? If you did, I get all your other points, and they may or may not be right, but if you're making this as a separate point, I don't see what's different between the reasons given, or what's different between the situation being considered, which would require different matters to have been looked at. You haven't identified what.
Sorry, different matters to be considered.
Well, you've already submitted that the reasons at 1 to 37 are not adequate for the 189B suitability question.
Yes.
You're saying it's not good enough then to say, and the same reasons satisfy me on the homelessness question. That means there must be some material difference between, if that's to be a separate point, there must be some material difference between what's required by the 189B2 decision and what's required by the main homelessness duty decision. We've already acknowledged that there is a nominal difference because one is suitability and one is reasonableness to continue to occupy. But you haven't identified anything particular, which means that that is more than a theoretical difference.
Well,
Have I made myself clear?
Yes, thank you, my lord. I think there are two things to say. Firstly, even if you were to elide the discharge of the 189B2 duty with the satisfaction of the main homeless duty, and therefore concern yourself only with the suitability of relief duty accommodation, which in my submission would be an error of law, even if you were to do that, these reasons wouldn't be sufficient.
Why not?
Is my first.
I mean, assuming you failed on the you're not just making again the point you've already made to us. So assuming you failed on 189B2, why wouldn't they be sufficient?
For the reasons that I've given in respect of Hackney and Hack, no structured approach.
Yes, but that's the ones you've given before.
I'm
sorry.
Well, it's a sum. All of those reasons together are, well, I said they were erroneous individually, and in some, they cannot possibly constitute a properly reasoned decision for the purposes of 1843.
Yeah, but then I thought you were making a new and further point about the homelessness decision. If it's just all the criticisms you make, home hack and so on, feed into the second decision, of course, I get that. Yeah. But that's a waste of your time to spend time on that. You've done that already. What's the new point?
So the new point is that you cannot, in fact, elide those two things. The new point is, where they say, I'm satisfied you have accommodation available for 56 days and which is reasonable to continue to occupy, for how long? Because it is that second part of that sentence which is relevant to whether or not this is accommodation which will be suitable.
Yes, I thought that's what you were going to say, but that's again a theoretical distinction. You've got to show that in the facts of this particular case, this may be suitable for 6 months, but is not suitable on an ongoing basis.
Yes.
And you've made no submissions about why that is so on the facts of this case.
Well, let me make clear, I think my Lord is inviting me to say what the differences would be on the facts of this case between suitable relief duty accommodation and that which would be capable of curing homelessness in the longer term. And if my Lord is inviting that, then I would say this. A hostel provides relatively little, say, privacy.
Hang on, this is a complete. Is this all in your skeleton argument? Is it? I haven't seen any points about privacy.
I think my reference to the code of
is at 17. Sorry, I'm.
No, I apologise, my Lord. It's paragraph 17.31 of the code. I think it is referred to in my
maybe it is. Forget that. Sorry. So you say it's because you can put up with this degree of lack of privacy for 6 months, but not indefinitely.
Essentially, that's my point. The code provides. The primary position is that B&B is short term. This is B&B style accommodation. Lavatories are shared, kitchen shared. Well, in fact, the kitchen is largely provided for, and there's only a small area for very minimal preparation of food in one's room. The question, stepping back, is that a way to live? And I appreciate that indefinitely is controversial, but is that a place to reside? Is that a place that's satisfactory for permanent curing of homelessness under section 193? Or rather, not permanent, but without end, without immediate end.
Thank you.
Unless I can assist further, those are my submissions.
Thank you. Anything else? No. Mr. Evans.
My Lords, the Respondent Council is not unsympathetic to those who are disabled and those who have genuine needs for particular types of accommodation.
That's not you, Mr. Evans, that's your client. Counsel with a CIA.
I would hope I'm sympathetic as well, my Lord.
No, well, okay.
But yes, that was the Respondent Council.
I was just bemused when you said the Respondent Council, as if I thought you were referring to yourself.
No, my Lord.
There's no apostrophe S, was there?
Yeah, yes, quite. I wouldn't take that point, would I? My Lord. But these cases are all about needs.
The Council is sympathetic to the needs
of the disabled, but the ramifications of that disability are, the authorities are replete with investigations and where to pigeonhole such matters. And what we say in this case is that, notwithstanding that there is type 2 diabetes, notwithstanding there's gastroesophageal reflux, these are all matters which do not render the accommodation which the appellant at the end of the day found for herself unsuitable, nor do they render it not reasonable to continue to occupy. And as I will take you briefly, there are many cases where those two particular concepts do flow together, or at least in parallel, and that there's so much overlap, and that is one of these cases. But if I could just emphasise a couple of factual points as we go through, which perhaps have not yet been This is a situation where, of course, even before the NAS accommodation came to be brought to an end, there were indications on the medical records of a long-standing diabetic problem. And in my chronology, I set out the various diabetic reviews that took place, and I'm not going to take you to each of them, but there were reviews in 2015, 2017, 2018. And if we just use, for example, page 209 of the supplemental bundle as an example, you'll see there a very long entry from the GP notes of a diabetes year of care annual review. And in the comment box about halfway down, that the patient was advised re-diet, patient advised re-exercise, referral to diabetes structured education program. So there a motivational interview done. There was a long-standing diabetes issue with this lady, and that was even before 2021. But again, even before she was feared or threatened as homeless, on page 325 of the same bundle, we may have looked at it briefly, there is, of course, the diabetes care plan from September 2021. And it's important to emphasise, as my lords have already said, that this does not actually say that there are specific food groups which must be excised from the appellant's diet, but that she should reduce the size of her portions, cut down on various foods, eat a healthy, balanced diet, include more grains and pulses, eat plenty of vegetable and fruit, and aim for 30 minutes of exercise. So that was the situation in reality. Now, when we come to the homeless referral, page 255, this was the 3rd of November 2021. It's important for me to emphasise that the appellant was not homeless until the 2nd of December. Her NAS accommodation did not come to an end until the 2nd of December. She was threatened with homelessness, and the local authority went through its inquiries process under section 184 because she was threatened with homelessness. But effectively, on the facts of this case, she moved straight from the NAS accommodation into Northumberland Park Hostel, which was this hostel accommodation that the council says was lawfully, she was lawfully directed to in discharge of the initial.
You said earlier she found it herself, which I didn't ring a bell with me.
Yes, I will take you to this.
No,
in fact.
Only if it's important. But
well, I think it is important because the local authority can secure accommodation in a number of ways. Section 205 and 206 say they can secure it by themselves, by their own stock, which wasn't the case. They can secure it through arrangements with a third party. Well, that's possibly engaged here, but it's more likely that they can assist with the discharge of their housing functions by providing advice and assistance. Now, in this case, what happened was, we can see, and I will take you to it, but straight after this document, there is mention on the homelessness referral of various medical conditions.
Sorry, which page are you on?
We're back at 255, my little supplement. So you'll see under medical details, diabetes, high cholesterol, hypertension. Of course, one wouldn't expect that to go into detail as to the effect on day-to-day activities. So I accept fully that the council was put on notice, as it were, of various medical conditions. But then we come to the situation that my Lord Justice Underhill was just exploring with me. If we look at, for example, the supplemental bundle at page 144, it would not have escaped your notice, my lords, that the Haringey Migrant Support Centre were assisting the appellant throughout the period of November. So we're on from about 8 days onwards from the document that we just looked at. They made contact, a gentleman called Mr. Robin Walden, the caseworker. There is reference on page 143 to the NAS accommodation as likely to come to an end on the 2nd of December. There is then various communications to do with documentation and obtaining medical documents.
So if you're doing this only to answer my question,
yes, I am.
Take rather a long time about it.
Right. Well,
what's the particular point?
Well, if we look, for example, on page 133, all throughout this time, Section 184 inquiries are taking place. By the 1st of December, the local authority had taken the viewpoint that there was no overt reason to believe there was a priority need. So they are not satisfied that there is a priority need, therefore there is no Section 188 interim accommodation provided. At this point in time, she's not homeless on the 1st of December. She's not homeless until the 2nd of December. She wouldn't be provided with Section 188 until she were actually homeless. There's no overt reason to believe there's priority need. And then there was a discussion about Northumberland Park Hostel. I assume in the middle of the page there, Haringey Migrant Support Centre, I assume you will anyway, but I appreciate if you can keep me in the loop regarding Northumberland Park Hostel. Then over the page, or preceding page 132, Anne Dos Santos, who's the case officer for the Respondent Council, the MPK hostel has vacancies, which is brilliant. They don't have interpreters. He asks, can you help me in the middle of the page with the nature of the hostel? And then for page 131, some details are given. Admittedly, it says 3 meals a day. It says there's a service charge. And then he says, great, can you please let me know, are the rooms at the hostel single occupancy? Can you please let me know what time's arranged so that I can be sure to be available? And then over the page, payment has been approved. The council offered to pay the first month's service charge. The address is Northumberland Park, the hostel. When she's arrived, the admin team can make the initial payment.
Well,
this was not
to show the exact opposite of what you were saying. You didn't find it herself, but it was proposed by the council.
Well, it was proposed by the council. It wasn't secured by the council.
Oh, I see. That's the only distinction.
Yeah.
Sorry.
Well, it is an important distinction. It's not secured. She's directed by help and advice to obtain accommodation.
Yeah. No, well, I knew that. Sorry, I must have misunderstood what you were trying to say.
And it's obviously she signed a contractual licence with a third party for the provision of a self-contained room with shared facilities in a hostel with a WC and bathroom 3 feet away from the door, and with all her charges covered by the £156 of heating, council tax, TV licence, and all those necessary matters, and 2 meals per day. So what we then have, of course, is after that no overt reason to believe priority need, we have a vulnerability questionnaire on page 157 of the supplemental bundle. And these are very detailed questions in which you would expect an applicant to provide any fundamental needs that they have. And I rely on the XY case in the bundle. I appreciate it's only a decision of the High Court, but one would expect, as that case says, that if there were any matters to go into the housing needs assessment and personal housing plan that were fundamental, that they would be raised by the applicant at the point in time that they were given the opportunity. Now, part of the criticism here, which was unwarranted, was that apparently this interview took place without an interpreter. It did take place with an interpreter. That was the initial claim on judicial review, which was wrong. And then the other initial claim was that this was 188 interim accommodation, which it was not. But you'll see there, for physical and mental health issues, I do not need to take the court to all of it. But there's a clear record of the physical conditions. Do you take medication for it? Have you deliberately hurt yourself? How does it affect you on a daily basis? In the middle, or 2/3 down on page 157. Over the page, mobility. Do you have issues with mobility? Learning difficulties. And then on page 159, other special reason. Do you drink alcohol? Do you have drug problems, etc.? And then on the top of page 160, other considerations. Nothing is provided by the appellant at that point in time. There is then a detailed section to do with management of day-to-day activities, including, are you able to prepare meals for yourself, and are you able to go food shopping? Now, one would have expected that if it was fundamental to the appellant's needs, that she would have raised at this stage the issue that she needs a special diet, that she needs to buy her own food, that her own food of a certain type if she had problem with management of her diabetes. But there isn't anywhere in the medical notes, as the review officer found, of any episodes of hypoglycemia, hyperglycemia, or any situations of serious lack of control of the medical condition of diabetes, so as to put the appellant at a particular risk. It is the feature of this case that these matters only came to be raised when the appellant engaged solicitors. And indeed, she had been in the accommodation since 2nd of December 2021. Mr. Dos Santos provided an email, Mr. Walden provided emails on the 10th of January after she'd moved into the accommodation for at least a month. And there was no reference at that point in time to any difficulties with the meal plans or any difficulties with the particular accommodation in terms of the location of the bathroom and the need to urinate frequently. These matters were first raised by the solicitors for the appellant. And the reason why that's important is because, as we see in cases such as SIDC, which deal with duties of inquiries, that there has to be a trigger for inquiries to be made. Clearly, the local authority were on notice of a diabetes issue and a gastro-reflux issue. But there was no indication that there was any reason for that to make any particular accommodation unsuitable. If there's a trigger, then one would expect the local authority to make inquiries, and it's for the learned friend to satisfy that no reasonable local authority would have failed but to have made those inquiries. It's simply not the case in this matter that it was Wednesbury unreasonable for Ms. Dos Santos and later for Mr. Minos Perdios, the review officer, to have failed to have made further inquiries into matters which were not at that stage triggered. So,
If you fall into the same trap as Ms. Murray by fighting a battle about the early stages, it's really only the review stage we're interested in, isn't it?
well, I am addressing all grounds because there is an issue here to do with whether or not the local authority could lawfully discharge the 189B initial duty by the provision of or securing or helping to secure accommodation of this nature. What my learned friend says is the only way that the local authority could legitimately provide accommodation of 6 months or more was by reason of a final accommodation offer or a Part 6 final offer, which is, of course, the main housing register. That simply cannot be right. There are many ways in which a local authority can secure accommodation or help to secure accommodation in discharge of its duties. If we look at 189B, and it is important to focus on what it says, and I'm turning now to page 26 of the authority bundle. So, as I've said in my written materials, what the 2017 Act did when it came into force on the 3rd of April 2018 was enable the local authority to slice up duties, something which had been frowned upon by this court in a case called Crawley and B, which is referred to in some of the cases that have before you, where really the local authority had to go through its full inquiry process. Are you homeless eligible, priority need, not intentionally homeless, and therefore have to do the full gamut? But of course, what the 2017 Act did was to interpose duties where someone is satisfied, or the local authority is satisfied that they're only homeless and eligible for assistance. And the whole thrust of my argument is that the local authority can be satisfied of those matters, discharge a duty, and Section 193 never comes into play. It never comes into play because the appellant is no longer homeless. And that, of course, depends on whether or not Section 175, subsection 3, it's accommodation which is reasonable for them to continue to occupy. But on the facts of this case, the suitability aspect and the reasonableness to continue to occupy are essentially the same in terms of the factual test. So, as we know, subsection 2, what that says is that the authority must take reasonable steps to help the applicant to secure. Now, as I've said, that doesn't mean the provision of accommodation, but may mean the provision of accommodation, and there are legislative indicators of that, which are section 205 and 206. And in deciding what steps they have to take, they must have regard to their assessment under 189A. It is not a criticism of this local authority that it did not spell out or reproduce in full within its housing needs assessment all the details that were in the vulnerability questionnaire. And I invite this court to take the same approach as it was in the XY case, if memory serves me right. That there is no one single composite document that the local authority have to maintain with every detail. If the housing file contains the vulnerability questionnaire in addition to the housing needs assessment that you've seen in this matter, then that should be, one would expect anybody picking up the file, the authority says, to read those documents as a whole. It would be more convenient, perhaps if the local authority had said in this case, please see vulnerability questionnaire within the housing needs assessment. But it's artificial to say there hadn't been a needs assessment. You've seen it there in the vulnerability questionnaire.
Can we just explore that one moment? So 189A says that you have to make an assessment, and the assessment must include an assessment of various things, including B, the housing needs of the applicant, including in particular what accommodation would be suitable, and so on.
Yes.
And then 3, the authority must notify the applicant in writing of the assessment. Now, do you say you did all that?
Yes, we say we did that by, on the facts of this case, the facts that were relevant to the suitability of accommodation were set out in the personal housing plan, because there had been no indication that there was any condition, medical condition, dietary condition, any matter of gastro-reflux, which would impact upon the suitability of accommodation. So the absence of reference to those matters within that document is not to be criticised in this case.
Can I just check how far that goes? So we've got, I think it's page 163 in the supplemental bundle. And I assume you say that this is indeed, whatever it is, the 2nd of December rather than the 15th of February.
It is. It's not for me to give evidence, but I'm instructed that when these documents are produced, they auto-generate a date.
Yes, I see.
So this is actually a matter that, from an earlier point in time, I can't tell you the exact date, my lord, but
I think
but it's not to 15th.
Pinkett gives it
patently clear it's not to 15th.
So we go on, and we're told that there's an assessment of personalised housing plan, and then we get the document starting at 164.
Single person. That's the first important thing. Single person would mean any accommodation would be suitable, per se, in terms of space and arrangement. That's the first thing. Then, if you like, these are the reasons why you became homeless. So that's the other part of section 189A. Client approached being evicted from that accommodation because she had leave to remain. She'd been granted status. So that is a clear explanation of how you came to be in the position that you were. So in terms of support needs, I say, well, yes, there isn't a reference here to diabetes, to hypertension, to gastro-reflux. That's all accepted. But that's not essential, because on the vulnerability questionnaire, there was no impact of those particular conditions upon day-to-day activities. And therefore can't be criticised at the local authority. You can't say it was one to be unreasonable of them, or that they failed to take into account a material consideration, because it wasn't a material consideration at this point in time.
Can I just take it a stage further? No. You say, well, this is all right. Suppose it weren't all right, so that you hadn't complied with your duty under section 189A3, or indeed earlier subsections.
It matters
the
not,
crunch line is, would it matter?
It matters not, my lord, because the ultimate accommodation was suitable. So there may be a sort of declaration possible that you're in breach of your 189A duty to provide an adequate assessment, but it's had no causative effect upon the appellant in this matter. And if it did, then that's been remedied by the internal review procedure. Because, of course, she's now saying, well, your housing needs assessment should have said these things, somehow presciently, that they should have contained, because our position is that no reasonable authority would be expected to make further inquiries. Then that criticism has now been raised. There's been the opportunity for full representations on review with legal advisors, where you expect then Cramp and Hastings, as modified by Holmes Morehouse when the case of a disability, that you would expect, or don't have to make inquiries, that a legal representative has variously suggested to you. But in the light of all that, there has been a full remedy available, statutory remedy, which the local authority have fulfilled.
So just pursuing it a moment longer. Supposing that there should have been in this document some reference to a medical condition. Supposing you get through to the review stage and the review officer doesn't know about the medical condition that would have been revealed in the proper personalised housing plan. Even then you say, well, there'd have been an opportunity for the appellant to comment and point it out. But supposing for some reason the appellant wasn't given an opportunity to comment and to point it out, then this might matter because the review officer would have made his decision in ignorance of a factor that should have been included in the personalised housing plan, which he would have known about if it had been there. But in circumstances where the review officer knows everything, you say it doesn't matter.
Absolutely, because it's substance, not form. The point of the HNA is to inform the accommodation which is provided, or as we say in this case, to which the appellant was directed. And if that still is accommodation at the end of the day that's reasonable to continue to occupy and suitable, that's why this case fails on the facts. It's not the right facts to bring the argument that the appellant does in this matter. We've seen subsection 4. Sorry, if we could just go back to 2, because there is a point of difference between my learned friend and I on the law.
And we're
Subsection
189B.
189B2, yes. Yeah, the initial duty, subsection 2.
Yes.
It's not a 6-month and 12-month maximum. That's wrong. That's not how you read subsection 2. What it says is the Secretary of State can bring up the level of the 6 months to at least 12 months. So section 189B2 is not a duty to help secure accommodation for a maximum of 12 months, if the Secretary of State so provided. It would be for at least 12 months and could be longer. So that takes out of the, or deals with much of Mona Friend's criticism of the local authority here, because she says, well, how could it be reasonable to continue to occupy if it's for a maximum of 12 months? It's not what the law requires. Subsection 4 is an automatic cessation of the relief duty if the local authority, during the course of its inquiries, has satisfied the applicant has a priority need. We didn't trouble ourselves with this because the local authority were not satisfied there was a priority need. No overt reason to believe priority need. So the way in which the local authority could legitimately discharge this 189B duty was under subsection 5 and one of the matters within subsection 7. And of course what it says here is that the applicant has suitable accommodation available for occupation and a reasonable prospect of having it for at least 6 months, or if the Secretary of State says at least 12 months, there's at least 12 months. Now, this is dealt with by Mr. Perdios, and we've had some rather interesting arguments about whether or not reasonable to continue to occupy means indefinite. I say Lady Howe didn't say that in paragraph 9 of Ali. What she said was indefinitely or for the foreseeable future. So the correct test, if you like, for reasonableness to continue to occupy, in my submission, is whether or not this was accommodation which was available to you and reasonable to continue to occupy for the foreseeable future. Now, it was clearly available under section 175 because there was an express licence. So you have a legal interest in a property. Clearly available, clearly reasonable to continue to occupy. Because if I could take you to the way that the review officer dealt with the temporality of the accommodation that was provided, that's in the review decision letter, right at the beginning, in the core bundle of about page 110. It's 113, forgive me. Clearly states at paragraph 1 the correct test. Whether or not we're entitled to end the relief duty depends on whether or not this room is available to you for at least 6 months and whether it's suitable for you. He deals with reasonableness to continue to occupy paragraph 39, as we say, and that's unimpeachable because he refers back to all of these matters.
So where are you reading from?
I was reading from paragraph 1 on page 115. Forgive me.
That's right, it was 113.
Forgive me.
Yeah.
Yeah, so paragraph 2, he actually deals with the quality of the accommodation in terms of temporality. He says it's provided to you by the hostel, you have a licence agreement on an indefinite basis and began on the 2nd of December. It is an unfortunate feature, I suppose, in a way, that the decision letter in this matter was the 14th of December, but the actual discharge of the duty in reality was the 2nd of December when the appellant found the accommodation. Because at that point in time, she had suitable accommodation for at least 6 months. It's confirmed to me that you're not being evicted. The legislation does not state that an applicant needs to have a particular licence or tenure in order to be able to bring the relief duty on the basis that they have 6 months accommodation. That's absolutely right. You'll find nothing in 189B and nothing in sections 206, 208 or 210 that say the accommodation must be of a particular tenure. So put into a long-term licence agreement is just one of the ways in which the local authority could discharge this duty. Another is a final accommodation offer, and I'll remind my lords that that is an assured short hold tenancy from a private landlord for at least 6 months. So if it's a 6 months period, and that's good enough for 189B, why is it that this hostel on a long-term licence, where a private landlord might not serve a section 21 notice after 6 months, but a long-term licence is somehow inferior accommodation to a final accommodation? It's not. He goes on to say, the only stipulation is there is a reasonable prospect of it being available for at least 6 months and suitable. Homes for Haringey, that's the council's arm's length management organisation, has an excellent working relationship with the hostel, and we know very clearly the nature of the agreement and how long a person can occupy it. Irrespective of the fact that the accommodation agreement states that only 13 weeks of accommodation is guaranteed, a minimum of 13, the reality is that as long as you adhere to the terms of the accommodation agreement, accommodation would remain available to you, not just for 6 months, but indefinitely. There's nothing wrong with a housing officer. This isn't speculation. This isn't the kind of criticism that's made in the learning for disability argument. This is based on evidence of the council's knowledge of the working relationship it has with the Northumberland Park Hospital. And that's borne out by the fact that 18 months later, the appellant is still in this accommodation, and she does not appear to have suffered any detriment by reason of the provision of the service charge meals. So, what we say in this matter, going back to the authorities bundle, is that 7A1 and 2 do kick in. That this is therefore open. This was a power, subsection 5. Subsection 5.
Just, Mr. Evans, we're just going to rise for a couple of minutes.
Court are acting able.
Sorry, Mr. Evans.
Grateful, my lord. On this issue of distinction between reasonableness to continue to occupy and suitability, it's an arid argument on the facts of this case, I say, but it's important to look at some passages you've not been taken to in the Roe decision, which is page 373 of the bundle, slide 16 of the authority.
Sorry, I didn't.
373
In the
divided
authorities
16.
In the authorities bundle.
Authorities, yes.
Yes,
We're looking at the Roe decision of this court, fairly recently, October of last year. In paragraph 27, of course, the court is looking at a situation where there's often section 1893 accommodation provided, and that logically reasonableness to continue to occupy comes at the point of the loss of the accommodation at the beginning, or that you may be homeless at home because the accommodation is so overcrowded or there's such disrepair within the premises that it's not reasonable for you to continue to occupy, and that suitability then comes at the point of discharge. But if I could take you towards the bottom of that paragraph, the emphasis that neither suitable nor reasonable are comprehensively defined, it's obvious that factors may go to whether continued occupation is reasonable, may, depending on the factor and all other relevant circumstances, also be capable of going to the question of suitability and vice versa. And paragraph 34, perhaps a matter which my Lord the Master of the Rolls made very early on. These passages emphasise the fact-sensitive nature of the inquiry that is involved when considering either A, whether it's reasonable for a person to continue in their present accommodation, or B, whether the accommodation being provided or to be provided by the authority in the exercise of their housing function is suitable. And then there are various references to the authorities, including the case of Timur, Lord Justice Jackson, and at 38, well, 37 previously, the paragraph at the bottom beginning, however, depending on the facts of the case, factors that may be relevant to the prior assessment of reasonableness may also be relevant to the later question of suitability and vice versa. It is more accurate to express the overlap in this way rather than say that concepts of reasonableness and suitability themselves overlap. So, and then paragraph 38 goes on to make similar points, the concepts being related. Now, of course, we've got a situation here where on the assistance, the help provided, the reasonable steps taken by the local authority to help the appellant to secure her accommodation, those two separate flows of stream did come together at the point in time of the 2nd of December. Because, and we see from the review decision, that notwithstanding that's the case, the review officer did compartmentalise those two particular matters. Because if I could remind you that the review officer considered availability first, we've looked at those paragraphs, but then there's the whole number of pages, starting with the core bundle, page 115, of the consideration of suitability. Now that starts with affordability, Samuel. It continues on to, and then a detailed consideration of what's your income, what do you get in, what are your needs, and therefore what you need to pay out. And then A minus B and C, he considers all those details and what the residual income is. Bearing in mind that this is the case where a lot of the matters which one would normally have to pay out for, like utilities, council tax, TV licence, were included within the service charge. So we can't take anything from the figure of £38.76 per week per se.
Well, there's no issue about any of this, is there?
No. But he then deals with cooking facilities and medical issues. And what we say in relation to that is there is a detailed consideration of each of the medical conditions and how it impacts upon the day-to-day activities. That is dealt with. So that's a sharp focus that HAC requires. And there isn't any criticism or any of those factors within paragraph 43 that were overlooked of HAC, that were overlooked in this case. And I'll come to the specific criticisms in a moment. But the general thrust is he looks at suitability in all those conditions over about 4 or 5 pages. And the sharing of facilities, which of course is said to be consequential upon the issues to do with the diabetes. And he compartmentalises that, and then at paragraph 37 comes to the conclusion that the accommodation is suitable. If you like, the reviewing officer then mentally pigeonholes that, because he then turns to the separate question under section 184 of whether or not at that point in time the appellant is homeless. So he goes back to the start of one's inquiries, effectively. And that's where we get paragraph 39. So he says, you have accommodation available to you, and it's reasonable for you to continue to occupy. So he addresses once more the test, or once for the first time, but goes back to the start and asks the test in section 175. This is based on the details that I have provided above. So it's reasonable for you to continue to occupy because it's indefinite accommodation, it's reasonably, it's available for you, and all the suitability factors as well. But it is a separate consideration in his mind. Doesn't elide these two particular matters. It starts again and asks the question, are you now homeless? And that was perfectly open to the review officer to make that decision. And then he says, in reaching both these decisions, so again, there's the emphasis there that there are two separate decisions, suitability and
Sorry, just
homelessness.
before you do that, I'm probably being obtuse. Why does it say section 184, not homeless decision?
Because the decision has to be given under section 184 of the Act.
Yes, I see. Yes.
Yeah, 1843. You have to have a reasoned decision. Now, I'm grateful to my Lord for the interruption because you've reminded me of what Lady Howe said in Unzola Mese, that reasons only have to be sufficient for their basic function. It wasn't necessary for the review officer here to repeat everything he had previously said. It was perfectly understandable from reading this decision from the appellant's point of view why she had lost on that particular issue. You're not homeless because it's reasonable for you, you've got accommodation available to you, and it's reasonable for you to continue to occupy. And he didn't need to go in any greater detail than that because he does say, I've provided the details beforehand. My Lord, does that hopefully
Yes, it does, thank you.
answer the question? So, my Lord, dealing with the specific criticisms of this, we remind ourselves that this is not a factual case where the appellant, as soon as she got into the accommodation, and she had the assistance of the Haringey Migrant Support Centre in as late as the 10th of January, which is in my chronology, the latest communication from there. This is not one where she was shouting from the rooftops that this food I simply cannot eat, cannot afford to be in this accommodation. It was a situation where the review officer, and again he looks at it, paragraphs 21 onwards, does a detailed analysis, in fact from 20 onwards, page core bundle 118, where he looks at the facts. Statement that you've been told to avoid pasta is not supported by the evidence from the NHS, and it's also not supported by the care plan that we've seen. It's not the case, as the appellant has asserted in her witness evidence, that I can't eat rice and I can't eat pasta. You mustn't be reliant on those foodstuffs. You must reduce the intake of them. Then he talks about Victoria Pinkett, of course, the officer who provided the witness statement in the judicial review proceedings. Hostel manager says you've got a choice of dishes. You could swap side dishes, as my Lord, the Master of the Rolls, has said, between options. Range of salads and vegetables. There's also some details in the emails about breakfast choices that you can see from my chronology. The meat's halal. There may be fried foods, but they have more healthy options during the week. Looking at the menus, he says they cater for a wide, balanced diet. Here are the breakfast options that are taken from the earlier emails. You could see, I don't need to repeat what is said. Then there's the comments, quite fair comments to do with, in the light of the medical background, about the very high BMI. And he says, I'm satisfied that you living in the hostel doesn't prevent you from exercising or losing weight. You can not only eat fairly healthily with the food options available to you, but you can also control the amount that you eat to aid weight loss. Fair comments. There's nothing in the medical indication, the medical evidence to indicate there's some medical reason why the appellant could not lose weight. And then there's the consideration of what happens on the days where perhaps the options are not the optimum. First of all, he makes the point quite properly in response to the representations that you're not prevented from eating pizza occasionally. And I've highlighted the NHS advise that you can eat anything, but just merely limit. In any case, on the odd day that there is something like pizza, you do have the financial resources to purchase something more healthy. So the criticism was there wasn't any factoring on affordability of the situation where the appellant was not able to eat anything on the menu at all. And the review officer deals with that. On the very rare occasions, he's effectively saying, on which there may not be something which is at all suitable for you, notwithstanding the fact that the appellant can eat anything, but just has to eat in moderation certain foods. Well, you do have the financial resources to purchase the odd meal. Given the above, I'm satisfied the hostel does meet your dietary needs. I say the criticism of the full reproduction of what was said in terms of the telephone call to the healthcare assistants. Well, I'd say that's not an error in the overall scheme of things, but if you were to consider it an error, my lords, I'd remind you of what Lord Newberger said in Holmes Morehouse, and I've put that in my skeleton argument, paragraphs 45 onwards, that there may be some errors which do not vitiate effectively the decision when read as a whole. But we don't accept that that's a valid criticism in the overall scheme of things. Yes, paragraph 31, I think is the point that's not the review of decision that's not been emphasised by my own friend with good reason. Is that the point being made on there was an urgent claim for judicial review here. N463 was put in on the basis that urgent interim relief was required because the appellant's health was at risk. Well, it never was. There's nothing on the medical evidence to indicate there'd ever been a serious medical condition as a result of high or low blood sugar. And the reviewing officer says this isn't an urgent case. So then he deals with the sharing of facilities, and effectively that is simply linked to what his decision was previously. He didn't have to accept everything the appellant said at face value. Hack, per Lord Justice Briggs, paragraph 40 onwards, I think from memory, make that clear. But there's this assertion that when my blood sugar is high, I have to urinate frequently. Well, he deals with that, in my submission, sympathetically. He says, first of all, well, I'm looking for the objective evidence as to what you say about that, and I can find nothing on the medical records. But his fundamental finding is that, well, the dietary requirements that you are provided with at the hostel, the 2 out of 3 meals, are enough that you shouldn't be in a position where you need to urinate every 20 minutes. But even if it's the case, so he looks at the matter in the alternative, even if it's in the case, there is a toilet adjacent to your room, distance of about 3 feet. If that's in use, there are other toilets in the hostel. Given the above, I'm satisfied the accommodation is suitable for you in terms of sharing arrangements. That's an unimpeachable decision on judicial review principles. And he says in 37, you've been occupying this accommodation now for 3 months without any serious detriment. Well, we'll now come, as I said before, forward another 15 months and it's still the position. As for the Equality Act, this is just the kind of case that was spoken about in HOTAC and then reflected in HAC, where a conscientious officer who didn't even know about the duties of the Equality Act or the express duties would, having gone through the medical conditions and considered the impact of them on the appellant's condition, would have satisfied the public sector equality duty, even though it didn't know that the Act required those specific things. Now, this is an officer who does know about the Equality Act. He's had regard to the disabilities. He doesn't need to spell out those disabilities. HAC tells us that. You don't need to go where His Honour Judge Luba Council, the Court of Appeal said, wrongly said you need to say what the disability is, spell it out in detail. You don't need to do that. The medical conditions that are relevant are detailed. And he says that I'm satisfied and consider the possibility to treat you more favourably. In so doing, I'm still satisfied that I'm entitled to conclude the accommodation is suitable and that it's Haringey is entitled to end the relief duty. So that's his conclusions. I say that's sufficient on the facts of this case, having looked at each of those medical conditions over a number of pages, that was satisfactory to discharge all duties. The relief duty, the Equality Act duty, the duty under Section 184. And unless my lords would like any further assistance, those are my submissions.
Anything else? Thank you very much, Mr. Evans. Ms. Marie.
Thank you, my lord. My learned friend said rhetorically that what material difference could there be between an assured short hold tenancy, say, a final offer of accommodation, which would discharge the 189B duty, and a long-term licence. And that was the phraseology, a long-term licence. Now, I've never seen this licence. It isn't in the bundle. It isn't before the court. I don't know the circumstances of its signing and I don't know its terms. In the decision letter, it's referred to as a 13-week licence. In the review decision letter, it's referred to as a 13-week licence. And at page 115, paragraph 3, the reviewing officer says they have an excellent working relationship with the hostel. But there are no details of that from the perspective of the appellant. And similarly, it being a licence, the reason it's a licence is because it's for a room only. It's not self-contained accommodation. The appellant will never be able to cook in any meaningful sense. She can only have a small microwave. It being a 13-week licence is substantially different in terms of security of tenure and in terms of the quality of the living arrangements thereunder as compared to an assured short hold tenancy. That's the reason why an AST is specified as being a final offer of accommodation, not a long-term licence, even if this could be construed as being one, it being only 13 weeks. There isn't any security of tenure with a licence, it's just a personal right. presumably under a licence, the hostel manager might be able to come in to the room without giving any notice. Presumably under a licence, they could serve notice and evict her with relatively lightweight procedural requirements. Presumably, they could change the charges for the services provided. Presumably, they could tell her to occupy a different room in the hostel. She could never, for instance, sue for disrepair. I have no information about the condition of the room, but it is only that. And that is incomparable, I say, to a right in land, such as one would have from a tenancy. And those considerations, those limiting features of a 13-week only licence and one premised on a working relationship, are things which a properly reasoned Section 1843 decision that you are no longer homeless ought to have engaged with. If the authority had done that, it would be possible to do what they are purporting to do. But that isn't what they did. Instead, they conflated the discharge of the 189B with the curing of homelessness unlawfully, because they sought to use subparagraph 5 and subparagraph 7A. Victoria Pinkett's witness statement said at paragraph 9, we contacted the hostel, and a review decision said that they have an excellent working relationship with them. It had to be the case that in order to discharge the relief duty, as the respondent purports to do, they had to have been convinced that there was a reasonable prospect of the accommodation being available for more than 6 months. It wasn't sufficient, therefore, to just say it's an excellent working relationship. What they needed to do there was go further to say why a 13-week licence translated into the possibility of not only discharging the relief duty, but also concluding that someone was no longer homeless. Further information was required in order to do what they were purporting to do there. And there is, to some extent, guidance available to local authorities within the code. Paragraphs 14.8 and 14.9 of the code, page 97, reports note of the authorities bundle. In some circumstances, determining reasonable prospect will be less clear-cut. That's the start of 14.8 and 14.9. Where this is the case, it is the responsibility of the housing authority to satisfy itself that there's a reasonable prospect of the accommodation being available for at least 6 months. It's on that basis that we say there is insufficient engagement with that test of reasonable prospect. Therefore, the relief duty was not lawfully discharged. But moreover and more significantly, the same considerations which might have, the same factual considerations that might have played in the decision maker's mind as to can I conclude that there's a reasonable prospect of this 13-week licence continuing for 6 months, should have been the same considerations which would have been necessary or would have featured in a lawful decision under 1843 against her interests that she was no longer homeless. And those are the differences that I just described between a licence and a tenancy agreement and between a room in a hostel and, say, self-contained accommodation, or a right in land and one that's only personal rights. So whilst this might have been suitable, my final point, whilst this might have been suitable 188 accommodation, and indeed perhaps it was, and it was provided on the 2nd of December, my learned friend says it was never provided under 188, but it was instead provided in discharge of the relief duty. However, that isn't the reading of section 188 which most makes sense. The 188 relief duty, the 188, sorry.
Does it matter anyway?
It matters because hostel accommodation is commonly used, and we saw that from the code, on a very short-term basis as 188 accommodation.
Yeah, but it doesn't. Yeah, but it depends on the facts. It's not saying this is more likely to be unsuitable because it was done under 188. All depends.
Overall, the appellant's submission is this may have been suitable 188 accommodation. It must logically have been provided as that. We know from 1ZB under 188, I won't trouble to take the court there, but 1ZB provides for a relationship between the first accommodation duty and the termination of the 189B duty. It must have been the case that this was 188 accommodation. It wasn't suitable as 189, and
Why not?
the decision wasn't properly discharged.
Why not?
Well, for all the reasons that I've already given, my lord, that it
Well,
was
then it might be unsuitable 188, but I don't quite understand where all this goes. What it was under? You mean what the decision maker had in their head at the moment they were doing it? Why is that legally significant?
It's legally significant because having placed her in accommodation that was suitable for one purpose, they then sought to conclude.
It might be suitable for both purposes.
It might be suitable for both.
Well, one has to see whether on the facts it is. In
But
which case it doesn't matter what they were thinking when they did it.
Well, I accept that as a matter of logic, my lord. But
That's what I'm interested in.
if the two tests are different, which they are, then it doesn't do to elide them and to say that because we've satisfied one requirement, we've therefore necessarily satisfied the other. And in my submission, that is what they do when they fail to engage with, for instance, the differences between an AST and a license.
And anyway, when you say it's obvious that it was 189, I agree there isn't very much evidence, but such evidence as there is was shown by Mr. Evans, which shows they thought, possibly surprisingly, but they thought that there wasn't reason to believe she was in priority need. It's there in black and white in the email. So if it is relevant to look at what they thought they were doing, they didn't think they were doing it under 188.
It says, I think, on the vulnerability questionnaire, no overt reason to believe priority
Well,
needs.
it's rather bad English.
Yes.
I don't know what overt means, but it's
That would in
not
my
quite clear what it's saying if it's not saying that we don't think we have to do this under 188.
But no overt reason would not necessarily mean that 188 wasn't engaged, because 188 has that low threshold.
I understand, but I thought you were interested in what was in their heads.
Well, yes, but in my submission it wasn't the legal test that ought to have been.
Well, now you're arguing what I was arguing to you, but it doesn't matter what was in their heads.
When they provided the initial accommodation, I say it was 188. And in any event, if they then concluded that she didn't have priority need, they ought to have written a decision letter under section 1843 saying we don't think you've got priority need and we're therefore going to accommodate you under section 189B instead of 188. There is no such decision.
This is a little unreal, isn't it? Because I can't remember, end of November, beginning of December, someone says, can't see an overt reason to think priority need. 2nd of December, your client is in the alternative accommodation. And then come the correspondence in February 292 of the supplemental bundle. They say they've received the pre-action protocol. Current accommodation was not provided under section 188. So what's the reason to think it was provided under section 188?
Well, the act and the low threshold.
What you're saying is it ought to be provided under 188.
It must have, whether or not they thought it was. It must have been
What
188.
does under mean in that context?
Sorry, my lord?
What does under mean? Under one section or under another?
Pursuant to.
But pursuant to must mean what the power the person thought they were exercising, isn't it? They may be exercising it wrongly.
Well, there is no duty to accommodate under 189B. There's only a duty to take reasonable steps, and she was
Right.
already accommodated. She was already accommodated under Section 188 because of the low threshold. She must have been as a matter of logic. She must already have been, but also not just as a matter of logic, also as a matter of construction of Section 188. It's at page 17 of the bundle. It does strongly suggest that the duty under subsection 1, so the interim accommodation duty, comes to an end when the duty owed to the applicant under section 189B2 comes to an end, which is rather suggest that you've already accommodated pursuant to the duty under 1, and then layered on top of that, there are 189B duties, which makes sense given that the threshold is higher. So this email on 292 makes no sense in my submission.
What? Sorry, I won't pursue this much longer, but Section 189B2 imposes a duty to take reasonable steps to help to get suitable accommodation. Why couldn't they have thought they were doing that?
When
Well, up to the point this accommodation is provided on the 2nd of December. Why shouldn't they? How do we know that they didn't think that they were doing that?
Well, as a matter of fairness, they ought to have told us if they were doing that, because there are no consequences to 188 accommodation, whereas 189B, accommodation occupied during the relief phase of 189B, does carry consequences. You can potentially become intentionally homeless from it. The duty can be ended. There are consequences, and there's a right to a review. If we were not notified that we were in fact under section 189B phase accommodation, and we thought we were under 188, well, we were not notified of our legal rights. We were not notified of our status. We were not notified of what we could lead to expect, and we were not notified that we could have a review of suitability relative to that duty, and to the question of whether or not it could reasonably be expected to be available for 6 months. All of that would have been highly material. Usually a local authority does write a letter saying we are hereby accepting the relief duty, but they did not in this case. So the assumption had to have been it was section 188. There was also never any negative priority need decision. Unless I can assist further, those are my submissions.
Thank you very much. Well, thank you both. Thank you for your submissions. We will take time to consider our judgments. We'll hand them down in the usual way. Please provide typographical but not other corrections, and then we will ask you to agree the order and consequential costs and everything else in writing. If you can't, we will decide it in writing. Thank you.
Court